Imagine holding that dark blue US passport in your hands, the emblem of freedom and opportunity that millions around the globe spend their entire lives chasing. You earned it. You waited patiently, studied, passed the tests, took the oath. You feel secure, untouchable, protected. It's yours forever, right? But what if I told you that your citizenship, the one you fought so hard to obtain, could disappear under certain circumstances? What if I said that right now there are government departments actively identifying citizens whose status might be at risk? That the permanence of your American citizenship might not be as absolute as you believe? Stay with me because what you're about to discover will fundamentally reshape the way you think about citizenship in the United States. Today, we're diving deep into one of the most misunderstood and, frankly, shocking areas of immigration law. Can you actually lose your United States citizenship? This isn't theoretical. It's not a what if scenario. We're talking about real legal processes, documented cases, and active government investigations that have led to the removal of citizenship from hundreds of people over the past several years. Whether you're a naturalized citizen, someone born on U.S. soil, or on the journey towards citizenship right now, this information is critical. Before we go further, hit that subscribe button and turn on notifications so you never miss an update. If you find this information valuable, share it with someone who needs to see it. Your support keeps this channel running and allows us to bring you the most accurate, up-to-date immigration content available. Let's challenge a common assumption. Many people believe that once you become an American citizen, you've crossed the finish line. Your status is permanent. You have your passport, your voting rights, access to federal benefits, and the full protection of the Constitution. Game over. You're set for life. That assumption is comforting, but it's not entirely accurate. Citizenship, whether acquired at birth or through naturalization, is extremely valuable, but it is not invincible. Legal mechanisms, government processes, and historical precedent all demonstrate that American citizenship can, in fact, be revoked. Yes, you heard that correctly. Citizenship can be stripped away, sometimes decades after it was granted. Now, before panic sets in, let me clarify. This isn't about the government whimsically deciding to take citizenship from someone they dislike. These are legally defined pathways, with due process, for cases where either voluntary action or misrepresentation has occurred. Understanding these pathways is essential for anyone who is, or hopes to become, an American citizen. We need to start by understanding the two categories of U.S. citizens. The first includes natural-born citizens, those born on American soil, including all 50 states and territories like Puerto Rico, Guam, and the U.S. Virgin Islands, as well as children born abroad to at least one American parent who meets specific residency requirements. The second category is naturalized citizens, people who immigrated to the United States, met all legal requirements, passed the citizenship test, and swore allegiance. Both groups enjoy the same constitutional rights: voting, passports, federal benefits, and equal protection under the law. On paper, a person born in Kansas has the same status as someone who naturalized after immigrating from Kenya 20 years ago. However, legally, the government treats these groups differently when it comes to revoking citizenship. Natural-born citizens enjoy robust protections under the 14th Amendment, making it nearly impossible to revoke their citizenship except in extreme cases of fraudulent documentation at birth. For all practical purposes, birthright citizenship is virtually untouchable unless voluntarily renounced. Naturalized citizens, however, occupy a different legal space. Their citizenship is the product of a formal administrative process. If fraud, misrepresentation, or illegal means compromise that process, the government has the authority to reverse it. This is known as denaturalization, the legal term for forcibly revoking citizenship. The most straightforward way someone can lose U.S. citizenship is voluntary renunciation. This is a deliberate, conscious choice, but it's not as simple as writing a letter or posting online. The law requires that you physically appear at a U.S. embassy or consulate abroad, meet with a consular officer, and sign an official oath confirming you fully understand the consequences. Renunciation is permanent and irreversible. Once processed, you lose your passport, voting rights, access to federal benefits, and the right to live and work in the United States. If you later wish to return, even for a visit, you must apply for a visa like any other foreign national. Why do people choose to renounce citizenship? The reasons vary, but taxes are a major factor. The United States is one of the few countries that taxes citizens on worldwide income, regardless of where they live. Americans abroad must comply with reporting requirements for foreign accounts and assets, which can be complex, time-consuming, and expensive. For some, renunciation simplifies financial life. Beyond voluntary renunciation, citizenship can also be revoked through denaturalization. This occurs when citizenship was obtained through fraud or concealment. Historical cases illustrate the severity of this process. For instance, a man from Bosnia who had participated in war crimes during the Yugoslav Civil War had his citizenship revoked after authorities discovered he lied on his immigration forms. Another case involved a former Nazi concentration camp guard who had lived in the U.S. for decades. He, too, was denaturalized and deported when his fraudulent history came to light. Denaturalization isn't limited to criminal concealment. Affiliations with certain organizations can also trigger proceedings. Joining a group hostile to the U.S., serving in foreign armed forces without permission, or involvement with foreign political organizations within 5 years of naturalization can be grounds for loss of citizenship. Even if you personally never engaged in violence, mere association can create legal vulnerability. The law requires the government to prove intent, but certain actions create a presumption of intent that shifts the burden to the individual. For dual citizens, navigating these rules is critical to avoid unintended consequences. Extreme cases involve treason, rebellion, or acting as an agent for an enemy power. Committing treason, engaging in armed rebellion, or providing intelligence to enemy nations can lead to citizenship revocation after a full legal process. These cases are rare, but the legal framework is in place and has been applied historically. Many Americans don't realize that the Department of Justice maintains a dedicated denaturalization unit. This team of investigators, attorneys, and analysts actively reviews cases of potential fraud or misrepresentation. They use data analytics, biometric databases, tips from the public, and international cooperation to identify individuals who may have obtained citizenship illegally. When fraud is suspected, federal court proceedings follow, with full legal rights to defense, witnesses, and evidence. If a denaturalization case succeeds, the consequences are immediate and devastating. Citizenship is stripped, passports revoked, voting rights eliminated, federal benefits lost, and the individual becomes a removable alien, subject to deportation. For someone who has lived in the U.S. for decades, this is life-altering. For natural-born citizens, the 14th Amendment provides nearly absolute protection, except in extremely rare cases involving fraudulent birth records. Such cases are extraordinarily difficult to prove, involving fake hospital records or stolen identities, and courts approach them with extreme caution. Across all scenarios, 3 core principles govern citizenship revocation: intent, deception, and fraud. Citizenship cannot be taken away arbitrarily. There must be clear, provable evidence. Either a citizen voluntarily renounces their status, demonstrates intent to abandon it, or obtained it through illegal means. Once the government meets the evidentiary standard in court, the outcome is final and irreversible. These cases have broader implications. They shape our understanding of citizenship, the balance between individual rights and national security, and the responsibilities that come with this legal status. For naturalized citizens, the lesson is clear. Honesty is paramount. Any omissions or misrepresentations during the immigration process can have consequences decades later. If you're considering citizenship now or in the future, understand the obligations and risks. Be transparent, disclose all relevant information, and consult experienced immigration attorneys if any concerns arise. Knowledge of these laws is essential to protecting your status and your life in America. U.S. citizenship is one of the most powerful legal statuses in the world. It grants rights, opportunities, and protections millions risk everything to obtain, but it is not unconditional. Understanding the pathways to voluntary renunciation or forced revocation and the responsibilities that come with this privilege is vital. If you found this video informative, hit that like button, subscribe, and turn on notifications to stay updated. Share this information with anyone who might need it: citizens, green card holders, or those pursuing citizenship. Drop your questions or thoughts in the comments. I read every single one, and it helps guide future content. Understanding your rights, obligations, and the law is the first step in protecting yourself and making informed decisions about your future. Stay informed, stay engaged, and remember, knowledge is your most powerful tool. I'll see you in the next video, where we'll continue exploring the complex and fascinating world of American immigration law. Take care.